Should you use an attorney for your divorce? Attorney Joseph Marra is going to explain the pros and cons of that very topic.
The court system has made it easier to do it yourself. There are plenty of forms. There's an office of the self-represented in each courthouse. But the more you have, the sillier it is to do it that way. And it's the old saying, you can be penny wise and dollar foolish. I'll just give you a quick example. And it's not only not using an attorney, it's using a cut rate attorney. Because you see these advertisements all the time. They say $4.99 for your divorce or $6.99 for your divorce. Well, they don't tell you also got to pay the court fees, but that's not a hell of a lot more. That's another $500. So, you got those fees on top of it. But let's say you can get out of this for $1,000. Should you do it? Here's a story to let you think about it. Husband and wife went to a cut rate attorney, okay? And they got divorced. Well, what they never factored into was the fact that they had a piece of vacant land that they owned jointly. That was never brought up in the divorce papers, never factored in. They had one child, by the way, and that is relevant as we go on. They never factored that in. So legally, what happens when you don't do that? As a matter of law, you now each own half that property. So we'll fast forward many years later. The child of the marriage got married and had children, and that child died. So now, and the husband, the original husband, we'll call him Grandpa died. So now Grandma got remarried, and now she has her 2 young grandchildren. And she says, you know what I want to do? I want to build a house on that land for my grandchildren so we can live there. Guess what happened? Well, since Grandpa died, his half passed to their child, but now she's dead as well. So guess where his half went? Her half went, the daughter's half. Since she had no will, in New York State, your spouse, and she was married, is entitled to the first $50,000 in value of assets, right, and 1/2 of the rest. So bottom line is, the kids, the grandkids, the minor grandkids, own a little less than 25% of this property. And the spouse, the surviving spouse of the daughter, owned the other 25%. And guess what? He was in jail. And he was not the nicest guy. So when I explained this all to him, I said, we can go to court, you have a guardianship over the children, this could all be done, but he's going to have to cooperate. He refused to sign over his interest in the property to anybody without getting paid for it. So finally, she just threw her hands up and said, I guess I'm not going to do it, and I'll deal with this somewhere down the road. So that's the risk you run of going to a cut rate attorney. If you have nothing, if you're telling me you're broke and you have no assets, you have nothing, literally nothing, great. Go pay the cheapest you could do it yourself. Most people have something, even if they don't realize it, quite frankly, or it's not in the forefront of their consciousness at the moment. Just like this piece of vacant land wasn't in the forefront of the consciousness of these 2 people and didn't become relevant until 20 years later when circumstances had radically changed. So that's a little story as to why you should not be penny wise and dollar foolish.
Thank you so much, Joe, for that important information. And thank you, audience, for watching. If you yourself or someone you know may have questions on this topic, please don't hesitate to pick up the phone and call the law offices of Joseph Marra. They are professional, friendly, and really great at looking at the pros and cons of your situation, coming up with a fantastic strategy, and giving you some options. We look forward to hearing from you soon.